Welcome to today's program titled Illinois Equal Pay Reporting Obligations. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Annette Timon. Annette, please go ahead.
Sorry about that, everyone. I am, my name is Annette Timon, as Kate said. We wanted to have this webinar to share some important information for Illinois employers. We announced that we would be moving forward with this webinar at during our last webinar on Equal Pay Day. Today, I am joined by Brandon Dixon, who is an associate here in our Chicago office. Together, we have been closely monitoring the requirements of the Illinois pay requirements that are going to be rolling out for employers that have more than 100 employees here in the state of Illinois. It is a significant change, and so we wanted to be able to talk with you about that today. We had hoped that when we scheduled this webinar that the proposed regulations would be out by now. Unfortunately, those, I believe, are still in pending mode. We do expect regulations to be coming out, as Brandon will discuss a bit more. But unfortunately, we at the time that we're moving forward with this webinar, that information was not available. But that said, we are going to continue on as we go into our next slide. We'll outline the agenda, which includes, just background information about the law itself. We'll talk about the application, right? It's referred to as an application that employers will need to obtain, what the components look like and what the process looks like. We're going to talk about some access to data issues. So what will be available to the public as Illinois employers provide this information to the state. We'll talk about the administrative procedures and penalties, and then some next steps and takeaways for you to consider as you move forward with the requirements. And so with that, I would like to turn it over to Brandon, who will give us some information from a background perspective.
My apologies. It seems that Brandon is muted as well.
Is that better?
Yes, thank you.
Okay.
Sorry about that.
No worries. I apologize. So again, everyone, good morning, good afternoon, depending on where you are. My name is Brandon Dixon again, and I'm just going to talk a little bit about some of the background of the statute. So the Illinois Equal Pay Act prohibits employers in Illinois from paying unequal wages to women and African American employees for substantially similar work. In March of 2021, the Illinois governor signed this major new piece of legislation that we're here to talk about today that was designed to target equal pay issues in the state. That bill was then amended in June of 2021 to address some pretty key issues. Particularly, there was a pretty wild sort of 1% gross profit penalty. And it also sort of gave employers the opportunity to a process to cure deficiencies in their application. And it also addressed some of the major privacy concerns that employers had with the initial bill. So with this law, Illinois joins California to become really the only second state in the country to require the collection and production of workforce pay data from private employers. And the Illinois law actually goes a step further that with its proactive requirement to verify compliance with certain state anti-discrimination and equal pay laws, as well as collecting employee level data from those private employers. Under the law, the basic sort of outline of the law is that it requires covered businesses in Illinois to obtain this equal pay registration certificate from the Illinois Department of Labor, and then to recertify every other year. And so go through this whole process again. So what is a covered business? So in Illinois, or under this law, I should say, a covered business is an employer that has 100 or more employees in the state. And an employee that is required to file an EEO1 report with the EEOC. Notably, that employee count is evaluated based on EIN, employer identification number, and includes employees who work in Illinois and employees who are remote but report to an Illinois location. It does not include Illinois home-based workers who work remotely and report to a non-Illinois location. So one of the biggest questions, that we've been getting since this law passed is related to the application deadline. So finally, at the beginning of this year, we got the first set of application deadlines. So under the law, employers that met the coverage requirement as of March 23rd, 2021, were required to obtain a EPRC sometime between March 24th, 2022 and March 23rd, 2024. As I mentioned, the Department of Labor has and will assign a specific deadline for each employer for their first application filing date. And that date will remain the same for for subsequent filings. I should note that the first and second notices have already been sent to employers, to some employers, and those employers have May and June deadlines. So those deadlines are approaching for that first sort of cohort of employers, or first two groups of employers. Future notices will go out on a rolling basis, but employers, at least as we understand, will have at least 120 days advance notice before they need to submit their first application. As I mentioned, the due date is going to remain the same for subsequent filings, and for those employers that have received notices for their first deadlines, at least as we understand it, those are the employers who have provided the Department of Labor their contact information. We have the link here for the form to provide that information to the Department of Labor, and that link simply requires that employers verify that they have the 100 or more employees in Illinois, and then ask for contact information, including email address, phone numbers for 3 contacts in the business to ensure that the department is able to reach someone in the business. And from what we've seen, employers have been using legal counsel or HR or diversity professionals, compensation professionals, just a smattering of individuals to, again, ensure that any communications from the Department of Labor are reaching someone with the organization. And with that, I will turn it over to Annette to talk in more detail about the actual components of the application.
Okay, can you all hear me? Somebody will tell me quickly if you can't hear me. I am not muted. So if we go to the next section, there's essentially 3 parts to the equal pay application process. The first is the filing fee. The second is the equal pay compliance statement. And the third is the actual EEO1 information and the wage data that employers are going to need to provide. With regard to the filing fee, it is going to be by, I'll talk about it in a little bit more detail, but you're going to be filing this information for Illinois by legal entity, for any legal entity that has more than 100 employees in Illinois. I saw that question come up a couple of times already, so wanted to make sure that that was clear. So the time frame that you're looking at is 100. It's 100 employees as of 12/31, and those are by legal entity in the state of Illinois. That's at least what the Department of Labor shared during a recent training session. So let's go to the next slide and let's talk about that equal pay compliance statement a bit more. Now, there are several components to this statement. It will need to be signed by a corporate officer, a legal counsel, or authorized agent, and they're certifying the areas that we have identified above. So the first is the statutory compliance. That they are in compliance, that the employer is certifying that they are in compliance with several laws on equal pay issues. That includes the Illinois Equal Pay Act, Title VII of the Civil Rights Act, the Federal Equal Pay Act, and the Illinois Human Rights Act. With regard to the compliance certification, we anticipate that the guidance is likely to track the Illinois Human Rights Act provision that currently essentially, requires some reporting regarding certain violations under the law, but essentially it's going to be that the employer hasn't had any final or non-appealable adverse judgments or administrative rulings, or to the extent they have, that they have resolved those, and it's going to be kind of a 1 year look back period. That's at least our understanding, but that's the kind of information that it would be helpful to have. As soon as we get those regulations, it will provide that additional context. Employers are also going to need to verify that they have a lack of wage disparity in their workforce, that the average compensation of their female and minority employees is not below the average compensation of male and non-minority employees. And it is going to allow employers to evaluate, accounting for factors such as the length of service, whatever factors you might use in your own workforces to differentiate compensation. That information is going to, is permissible in terms of explaining a lack of wage disparity. Employers will also have to certify that they do not make sex-based personnel decisions, that employees are not restricted into certain classifications based on sex. They also have to certify that to the extent any wage disparities are identified, those are addressed. They will also need to provide information with regard to how often their wage and benefits are evaluated. Even though there's no requirement in Illinois outside of, perhaps affirmative action principles that some federal contractors may have, employers here in Illinois will have to provide information with regard to how often they conduct or evaluate their compensation. And they will also need to provide information to the Department of Labor regarding the approach they take for how they set wages. Okay. Now, interestingly, during a recent training session that the Department of Labor, they are making those available primarily to those employers who have those upcoming deadlines, the May and June deadlines that Brandon talked about. They shared what the compliance statement was going to look like. So initially we were wondering whether this was going to be sort of a free form kind of document, but it is in fact a document that the Department of Labor shared on the screen. We certainly were hopeful that the information would be available, but they're still making revisions to it. What I can say is for most of it, it is someone is filling in, insert your name, certify the following, and most of the information is just, like one, for example, the statutory compliance one just says the business is in compliance with, and it lists the 5 laws that they're in compliance with. Number 2, it's just an affirmative statement and then someone is signing off that they are in compliance. The last 2, however, are a little bit more fill in the blank. So the frequency of the wage determinations. So it's at least right now, we'll see what ultimately is finalized, but at least the version that we saw during the training session was that it said, that the employer provides or wages and benefits of employees are evaluated on the following basis, and then it's a fill in the blank every blank month or year, and you circle one of them, and then it has a place for other to describe what that looks like. And then the last one for the analysis of the wage determinations, it's a little bit of a some options, selection options, as well as a potential fill in the blank. And the question currently, at least the one that we saw, was the business utilizes the following methods to determine employee compensation and benefits, and circle all that apply. So some of the options that at least were on the form that we saw is, a market pricing approach, state prevailing wage or collective bargaining agreement requirements, a performance pay system, an internal analysis, or an alternative approach, and that's where employers are going to have the option to fill that in. That information is followed by a certification that says, the undersigned hereby certifies that they're a corporate officer and that the statement is true and accurate at the time of signing. The person who signs off on it, prints their name, and provides their title and business name with the submission. So that is the compliance statement that is going to be required of all employers. Then if we go to the next slide, we the EEO and wage data, right, is the next piece. And I'll show you in just a moment the template here. This one is currently available on the EEO, excuse me, on the Department of Labor, Illinois Department of Labor's website. And what employers here are going to have to provide is their most recent EEO-1 report. They clarified that even with regard to employers who are filing in May and June, they will need to provide their 2021 EEO-1 pay report, or excuse me, not pay report, EEO-1 component 1 report that employers are in the process of filing. So that one's going to be a really tight turnaround, whatever you submit for your EEO-1. Then in addition to that, the template form, the Illinois requirement is employee level data. So it's not, if you have many of you may also have responsibility for California requirements, and employers are, they have until tomorrow to get that information in. It's also not like the EEOC's component 2 data that was aggregated in some ways. This is your employee level information. They want to see the name, the last 4 digits of the social, the gender, race, ethnicity, the total wages rounded to the nearest $100. And in the last training session, they shared that employers may use box 5 of the W-2. Now, they also are going to require the hire date, termination date, the EEO-1 job classification, and the job title of the employee, along with the county where the employee works. Now, one point is that the training material, there's a template document that says hire date and termination date. However, the training materials, there's some PowerPoint presentations that are on the Department of Labor's website that if you haven't attended the training session, you should, you can look at that. It does specifically refer to, rather than the company hire date or company termination date, it refers to the job end and the job start date. So that is a bit of a nuance that employers, if you're pulling data right now, you need to think about that, certainly until we see the official guidance from the agency. But that seems to be, that's what they're confirming. I'm not sure if they're going to update the template form to have a spot for example, for the company term and hire date so that you have company tenure as well as job information. But, you know, in our experience working with employers, sometimes getting the jobs that an employee worked, and these are only the jobs that they worked in over the course of that year, it's my understanding, not their entire employment history, just for that particular year, what information they should be providing. So that's the template form itself. The data certainly can be manually added, or you're going to upload that information using a CSV file. As many of you are probably familiar with. I think that's everything I wanted to cover on that particular slide. Some of the just clarifying points that came through from the training session, I think I've touched on this already. It is by legal entity. So each legal entity, we know that many employers have a complex reporting structure, or a complex organization structure, I should say. And so for the Illinois requirements, it is, you know, you look at each entity, if they have each legal entity, if you have more than 100 employees in Illinois, those Illinois reports are going to be required to be filed separately, each with their own filing fee. Okay. That 100 employee threshold applies as to each EIN. So each employer company is going to be dealt with separately. So if you have 5 EINs and every one of your companies has, you know, only 90 employees in Illinois, that specific question was asked during the training session, and we were advised that no, that employer would not be required to provide, even though in the aggregate they have more than 100 employees. That employee threshold in terms of the 100 count would be based on a snapshot as of 12/31. Okay. The parent organization may actually do the filings, but again, it has to be done for every single location. There is a data collection point for headquarters for that employer. Certainly the headquarters address can be outside of Illinois. As I mentioned already, the filers that have a requirement for 2022 will be required to file include their 2021 EEO1 filing report for your Illinois location. So rather than submitting your entire EEO1 report, we asked that question and we're advised that it's only the EEO1 establishments data that would need to be provided for purposes of the EEO1s. Now, one other important point is that unlike the EEO1 report, unlike the California report, this is not a payroll, snapshot payroll period driven report. The information that is being requested, at least based on what they have shared, is that they want to have data for all of the employees that were employed during the reporting year. So that means your counts will not match your EEO1 reports necessarily. So even if you're, reporting on a particular location, you may have folks that terminated earlier in the year, for example, and weren't on the selected payroll period that you use for your EEO1 data report. At least what they have shared so far, which this is another area where we'd like to see the regulations specifically from the agency. They have shared that it's going to be all employees. You are, as I shared, you can report or can use box 5 of the W-2. And the additional piece of information is, on the form itself, if you have more than one job in the reporting period, the employee should be reported separately for each individual job title they have. I am, hopeful that there's additional clarity regarding, does that mean for every single job, or does that mean only if there's a pay change that goes along with it, if there's a promotion that goes along with it? It's just not really clear. And so again, hopeful that information, there's additional clarity on that. Let's go to the next slide, and I hope that you can at least see the template a little bit. This is definitely, and you will get all of these slides. I know I've seen a lot of questions about that. There will be a slide, and the recording of this will be made available after this uh, presentation. But at the bottom of this particular page, we included the website that, the Department of Labor has this information. If you're going on it, you go to the Illinois Department's website and then you look for laws and rules, and under the Equal Pay Act, that's where you'll find the materials. It wasn't as intuitive, at least for me anyway, when I was looking for it. So we provide that information. So it's a fairly short form in terms of the information that's being captured. And but it describes the components themselves. Gender is female, male, and X for non-binary. Race information has been updated. There was a change there. And I believe we just pulled a new one today. I think we still might be missing administrative workers. So I think that's another area that for the EEO1 report may not match up exactly, but that's essentially what the data looks like from a template perspective. I've seen some questions about a timeline to provide contact information. So as Brandon shared, employers do need to provide contact information to the agency. That is one of the key ways. It's not the only way, apparently, but it's one of the key ways that the agency is reaching out to employers to provide them with, your deadline, right? Now, I have heard that I haven't seen it. I'm not sure where it's exactly coming from. I have learned that some groups have said that there's a November timeline, November of 21 timeline. I have asked the question of the Department of Labor. They certainly takes the position that if you haven't already provided contact information, you should do so. So that they can get you in the queue for the process of producing the reports. It's my understanding that there is one more uh, uh, I guess wave that'll be coming in 2021. So I think by September or so, another group of employers will be filing or submitting information, and then we'll likely see the rest of them come up in 2023. Just one final point is, what's the process going to look like? What is the department going to, kind of what's their response? You're seeking this is an application for a registration certificate, essentially. So the employer files the information with the agency according to the requirements. The Department of Labor has 45 days to get back to employers with either approving their application or rejecting it. And if they reject it, then the employers have an opportunity, another 30 days, to cure any identified deficiencies and to provide that information to the agency. If it is approved, as Brandon shared, there is a 2-year requirement for producing the information again, and it's going to be on the same date. So if you're one of the employers that is filing May of 21, you'll be doing the same 2 years later on that same May deadline. I'm hearing some background noise. I don't know if others are hearing that. Hopefully not, but I'm hearing a little bit of background noise in my ear. I think that is what I have. With that, I'm going to turn it over to Brandon, who's going to talk about some access to data issues.
Thanks, Annette. So as I previewed a little bit earlier, in the first version of this bill, so one of the biggest things that caused employers heartburn was the fact that, this is sensitive data that's going to be shared with the government, and sort of who's going to have access to it, how is it going to be protected? And at least as of now, we have, some understanding of what the department is going to do in that regard. And so as we know right now, the aggregate data, so data that's reasonably calculated not to identify individual employees or individual businesses, that information is not confidential. So this includes job category, average hourly wages by county for each gender, race, ethnicity category. The Illinois Department of Labor can compile that information and share that aggregate data. It's also important to note that as Annette was just talking about, sort of that decision tree where it's, the department may approve or deny or revoke an application, that information is also public. We're not sort of sure at this stage what that means, sort of how it's accessible publicly, but that information, importantly, is not going to be confidential. With respect to, on the next slide, individually identifiable information. So this is information, the employee level data. That information is going to be deemed confidential, or information, I should say, that's associated with a specific business. That information is deemed confidential and it's not subject to disclosure pursuant to an Illinois FOIA request. However, employees may request anonymized data for their job classification or job title within their county. And again, this is another question we get a lot from employers about sort of how will the department know that it's an employee, a current employee requesting this data, right? Could it be, what if it's, enterprising plaintiffs attorneys who are sort of digging around and trying to kind of figure out if there may be issues at a particular company. And so at least, again, as of now, we understand that there's probably going to be a requirement of some sort of affidavit to have the individual who's requesting the information, affirm who they are and who they say they are. Another potential issue is, small groups, small categories groups, or you can imagine a situation where there's a employer who's, for lack of a better term, sort of the only game in town, right? And there's only a small number of, highly compensated sort of individuals in that executive category, right? And so if there's only one or two people in a category in a specific county, it's going to be pretty easy to sort of de-anonymize that data and figure out who's getting paid what. And so that's another question we've posed to see if there's going to be some sort of protection where you have these small groups of employees in a specific locale. And we haven't really received kind of a satisfactory answer on that one yet. So turning to sort of the next topic on administrative procedures and penalties that come along with with this new law. So the Act allows the Department of Labor to suspend or revoke an application of an employer if that employer fails to make good faith efforts to comply with the Act, if the employer has multiple violations of the anti-discrimination statutes to which it certifies compliance. So again, the Illinois Equal Pay Act, the Title VII, Illinois Human Rights Act, et cetera. So multiple violations of that may result in a suspension or revocation of the certificate. However, before the department revokes the certificate, they're required to conciliate with the business concerning any wages or benefits, it's arguing are owed to or due to employees. The Act also specifically allows the department to interview workers, to take depositions, subpoena witnesses, personnel records, compensation records, all in connection with any sort of potential suspension or revocation of an equal pay registration certificate. And then in terms of penalties and enforcement, so falsification or misrepresentation of information on the actual application itself can result in penalties, including suspension or revocation, or civil penalties of up to $10,000. The Act allows businesses to request an administrative hearing prior to suspension or revocation of its certificate or the imposition of civil penalties. And to the extent your business wants to request that hearing, it must file that request within 20 calendar days of receiving notice that it's either going to have that be certificate suspended or revoked, or notice of a fine. And before I move on, I want to give out the CLE code. The code is SS 4432. That's SS as in Seyfarth Shaw 4432. And with that, I'll turn it back over to Annette to talk about next steps and takeaways.
Okay, terrific. So hopefully you all can hear me. Again, here I was just answering a question privately there that came through the chat, and I'm going to do my best to hit some of these questions that are coming through. So as I have shared in terms of what's next, we certainly are awaiting the proposed rules to be coming. Employers with pending deadlines have been invited to attend. I would encourage you to attend those and get your questions specifically answered from the Department of Labor. They have been that's one thing I will say. They have been very, very responsive to questions that are being asked. Sometimes, you know, it sort of causes them to think a little bit more about a particular question that comes up, but they have been very, very helpful. And so I encourage you to reach out directly to them, you know, with specific questions unique to your organization and to your filing process. I did get a lot of questions. Let's go to the next slide. But I did get a fair amount of questions about the contact information. The contact information, it was a primary means for reaching out to employers to provide deadlines, but I am aware that the agency did obtain contact information in other ways. So some employers that did not provide their contact information nonetheless received deadlines. And so it's important to be mindful of that. The other thing that I will say is that in the law, as a matter of law, right, employers will have to file by March 24th of 2024. And so if you, for some reason, don't get a deadline, miss a deadline, it's going to be on the employer, not the Department of Labor. So it would be deemed to be a violation. There is some language about, you know, if you didn't know, essentially, or if the Department of Labor didn't give you a deadline, then that perhaps could be a caveat. But it's really important to keep in mind the information that's there. It's actually one of the last points, not just to provide the information, but to make sure that you have a process to continuously update that contact information. The notices are going out via email. I'm not aware that they've sent any sort of paper letters, right? In our current environment, they're using emails. So if you have an employee that, you know, either leaves the organization or isn't in that role anymore, you still want to make sure that you're providing the Department of Labor with the most up-to-date information so that when they send a notification with regard to your filing or, you know, hopefully not, but, you know, a non-compliance or a question about your submission, you're going to want to have, you know, that free flow of contact information availability. So it's important to do that. Other things to make sure that you're doing now, certainly in light of the sensitive nature of the certifications in particular, as well as the data that's being provided, you're going to want to make sure that your key stakeholders, that could include, you know, HR, IT, legal, comp, and others, that they're aware of the certification and reporting processes. You want to make sure that the data is accessible in the format that's requested. So one of those nuancy things that, you know, you're going to perhaps have to pivot on is, you know, you need to provide all employee information, not just those employees that are in that particular snapshot. So that kind of thing is going to be different than other reporting requirements. And so you're going to want to have your IT folks pulling that, or whoever's pulling it. I shouldn't just say IT folks, but your compliance team's very well aware of the requirements there. You need to be, you know, considering, as always, you're doing these robust pay analyses. We recommend that you're doing those under privilege, but, you know, you have to rethink how you're doing them. Very often companies are doing them company-wide, or, certainly not by county and not just for Illinois workers. I do a lot of pay equity reviews and I don't see it coming up that way. So consider whether in response to these specific requests, there's a need to do your analysis that you might be doing in a different way. Now, unfortunately, it is not clear how the agency is going to look at it. I saw a question about whether the difference, a statistically significant difference would be appropriate or what the standard would be. In Illinois, it follows it's equal pay, right, for substantially similar work. That is the analysis. Now, this is EEO1 data. Certainly by job, you're going to want to include job information. So these are the kinds of things, though, that you need to be thinking through because there is an actual certification requirement that goes along with it. You also want to develop a strategy for responding to any employee inquiries that you may receive. As Brandon shared, this is unlike most other requirements, and there's an opportunity for an employee to access compensation information with regard to their own job title or their own job category for their specific county. So they may be coming to you to ask questions about their compensation. And note that the template information that I shared with you, leaves a lot of information out of the picture. For example, whether someone is part-time or full-time is not included. And yet an employee may be getting compensation information about, pay information for other not by name, but other individuals, and that is going to may potentially cause some concerns or misunderstanding, I should say, about the compensation information. So having a strategy in place before you start getting questions, at least to know who to go to, I think is going to be very important to do. There's one more slide here. I think it's just on the life cycle of a pay audit, which many of you already are doing. So we will leave it there for the materials. I'm going to try and hit some of the questions because there have been a lot of questions that are coming up, and I'm going to try and hit some of them if I can. So one of the questions was, if I have 2 business entities of 51 employees, do we need to file? And so I would say to that, based on what they shared, you're going to be looking at how many employees you have by EIN number in Illinois, and they referred to the reporting location. So I've seen lots of questions about, well, I have remote workers. How do I count those folks? It's, how are you thinking about them for your EEO1 report? If you're reporting folks to, a reporting to location here in Illinois, and that number exceeds 100, and they're in the same EIN number, so, the business entity, as long as we're talking about EIN number, those would need to be reported if it's over 100. If you have 2 of 51, but there are 2 different FEIN numbers, then you do not qualify according to what the agency shared during the training session, okay? Gender is male, female, and there's an option for non-binary, so X is a data collection point as well. I think I answered the question. Hopefully I answered it about the contact information because you may end up getting a notice regardless, but don't leave it up to chance. The agency certainly is looking at employers to provide the information. Again, it's a reporting to location. So where do you have employees reporting to? And if you're struggling with that a bit in the absence of additional guidance from the Department of Labor, it's supposed to be tracking in some ways your EEO1 report, right? So consider how you're doing it there for consistency purposes. If you have not received a notice yet for May or June, I believe you would not be included in that deadline. If you have questions about it, you can certainly contact the agency. That's what they have suggested, that you could go through and ask them specifically if you have any questions around whether or not you've received a deadline if you have questions about that. Otherwise, you probably have not. If you are, let's see, Yeah, the permanent hybrid locations, I see a question here about, permanent hybrid. You do have headquarters in Illinois. It is likely that you have a reporting to. So those employees, to the extent you have them reporting to your headquarters in Illinois, then it's likely going to be, I mean, again, I would come back to how are you reporting it for purposes of your EEO1 report. So if you exceed that threshold, even with remote employees, then you would be including them. There are several that are the same type of questions, so I am hitting those at the same time. Someone asked about the who should be signing the form. It could be anyone that the organization identifies. It's going to be a corporate officer or legal counsel or authorized agent. So you could have um, perhaps the same person that submits your EEO1 report could be someone that does it. It really depends on the specific organization, but certainly they have to be an authorized agent to provide the information. The employee counts again are, it's not aggregated across the affiliated companies. It is by FEIN based on what they shared. County information is where the employees work. Yes, that is correct. Those employees that have not disclosed, the EEO1 requires you to collect using a visual identification. So you either use employee records or you use visual identification for those who decline to self-identify their race and gender. So that is maybe an option as well in Illinois. Again, it would be great if they came out with guidance. And I am sorry, off the top of my head, I cannot recall if it explicitly is permitted in Illinois to collect that visual information the way it is in Illinois. So we may follow up with that. I'm trying to go through these questions quickly. Someone asked a question about how the terms in rehire events should be shown on separate line. I mean, that's a great question. I am not sure how the agency is going to require that information. It's a pretty it's just an Excel form and pretty basic in terms of the information that you're providing. I believe that they're, going to be providing additional information about that. And hopefully we'll create additional fields for the information to the extent that that is required. Someone asked the question, they heard that federal contractors were not required to provide the pay data. If that is true, that would be news to me. I would be happy to follow up on that because it is my understanding that federal contractors are not exempted. So if you have at least 100 employees and are in Illinois and you are required to complete an EEO1 report, which federal contractors certainly are, then I believe that you do have a reporting obligation. I'm not aware of any exemption that would apply for federal contractors. So there's an interesting question that came up about, the official head count. So we are looking at it, at least what they shared was 12/31 was the date of the head count. And so a question came up about, well, if you have 95 employees on that date, but you terminated 6 employees throughout the course of the year, does that get added? That is a great question to submit to, to contact the office about. Based on what they've said, 12/31 is the snapshot date. So I would say that you're under the 100 employee count in the absence of additional guidance from the agency. Interesting question about the practical implication of a suspension or revocation. There is I believe it's a $10,000, right, penalty. But at the end of the day, the fact that you are suspended or your equal pay certification is revoked is going to be a matter of public record, right? Your employees could potentially get access to that information. Competitors could. If you're bidding on projects, that is information that could be used against you as well. And so I think the practical implications, in many ways, the reputational harm is probably a more significant concern to a lot of employers certainly the financial penalties as well, but not having that or not having that stamp of approval, I think in this environment would be considered pretty problematic for most employers from a practical perspective. The questions in terms of why the information is going to the Department of Labor, or we received a question about any insight as to why employee request for pay data would be to the Department of Labor versus to the employer. Most employers, I mean, this is actual employee level data. So when we say that employers or an employee can seek the information regarding compensation, we're not talking about what the pay range is. We're talking about the pay of other employees in the same job category. It's not clear to me whether it's going to be, average pay, range of pay, that's going to be provided. So for example, if an employer has a range that they can pay for, whatever job that we're talking about, let's just say an accounting job, and they can pay anywhere from 60,000 to 95,000 for that position. In many states, that range is required to be posted on a posting or provided upon request, depending on the state that you're in. Here, we're talking about something different. And so most employers would not share the compensation of other employees. Certainly, others could have more experience, higher level of expertise, whatever there might be. But here it will be allowing employees to obtain information specific to their county and for their own job or job classification from other workers. Let's see, I think I'm hitting most of them. If the employee works from home in Illinois but is tied to an office outside of Illinois due to the employee's business unit, does that employee need to be reported? We asked that question and we were advised that the answer to that is no. It depends on where you're reporting that particular employee. The reporting location, not where the person lives, is the relevant information. Who are they sending the information to in an organization? It depends on who you provided from a contact perspective. So the form that Brandon talked about, where you go in and you provide your contact information, I think it gives you an option for up to 4 employees and of course email addresses along with it. What I am not certain about is how I'm aware that the agency got contact information from other means. So lists, they went to various vendors who had employer contact information. I assume that had email addresses, but I'm not sure exactly what level of contact information there was. Again, if you have questions about whether you are on the list or not, or especially if you filed your contact information but you haven't received notification and you're concerned about it, you should go ahead and contact them. I would also say that it's probably unlikely that in the beginning you're going to get flagged. Certainly the Department of Labor, they have been, quite reasonable in working with employers and providing information to the agency. At the end of the day, though, it's still a compliance obligation. So if you have questions or concerns about whether or not you've received a notice or a deadline, you should definitely, reach out to them. There was a question about if you submit in 2024, what is the year you would be reporting, 21, 22, or 23? If you have a filing deadline that comes up in 2024, you would be providing information about the previous year. So it's always a 1-year look back period. At least that's my understanding as of 12/31, because again, it's year end compensation information that you are producing. Someone asked the question, my company received a deadline to register with the state this year, but we don't have to actually, and the question is, do we have to actually pay the fee and the data until 2024? No, if you received an actual deadline, especially if it's one that came up, it's coming up in May and June, you will have That's your deadline to actually submit your certification. The way they wrote it is under the law, everybody has to file, by 2024, March of 2024, and as early as March of 2022. But, one of the things that we talked about was the timing. So employers submit their data, and then the Department of Labor has 45 days to respond. So imagine if all of that information came to them at one time and they had 45 days to respond to every single employer that has operations in Illinois. That would be very difficult for them to do. So the reason why they're doing these staggered deadlines is to try and navigate some of those issues. So just keep that in mind. If you got a notice that has an actual deadline to register, take a closer look at that. If you have any questions, definitely call the state and ask them, the Department of Labor, and ask them about it. On the website that I shared with you, there's some contact information that they have provided, and you should definitely be reaching out to them to provide the information.
And I'll just
Yes,
add a clarifying point that it doesn't seem like we, at least as we are aware, there's no deadline to get your contact information in, right? The department has never set that deadline, at least that I've sort of learned of.
yeah. I asked that question because I had heard for some reason some association groups were putting out that November of 2023 was the deadline, and I hadn't seen that anywhere. So I did ask the question from the department, and what I was told that, without confirming one way or the other that November date, I was told that it was their position that if an employer has not provided that information, they would be out of compliance. Now, to my knowledge, there's no penalty for not yet having provided that information, but it's definitely something that you need to be very mindful of, that that's the position that they're taking up at this point. Certainly, there's a lot of questions. So before the training session, for example, I had not fully appreciated that it was each FEIN number with more than 100 employees has to file. So that matters significantly because your contact information may or may not be, may be different. If you have 5 FEIN numbers with more than 100 employees, you should be providing contact information for 5, or at least all of the information goes to one person who is aware and has the ability to make sure that all 5 legal entities have the relevant information that they need. So that is one example of, I think, a clarifying point that is, quite important for employers. And I know that the Department of Labor is certainly, they have been, working hard to try and get all the information out there, but it is a new requirement to them as well, right? So yeah, there is a question here. The first step is for companies to register with the Department of Labor and provide contact information. So yes, I would say, yeah, you do have to provide that information as a first step. I think I have answered most of the questions. There are questions about, there's questions about the additional factors, right, that influence compensation. That information, that is key information. So you are certifying that your compensation is influenced by, additional factors other than what you're providing to the agency. So you can meet that obligation by providing it. And then I think it's, in terms of the certification form itself, right? So you can actually say that based on the factors that you consider as an organization, that information is readily is used to factor in, so you've got that certification and can make that statement affirmatively. On the data that's provided currently, there's minimum information that is requested. If the agency asks follow-up questions, then I think that's when you have the opportunity to provide additional information with regard to an individual, because there's a lot of additional data I think that's missing. But until we have a better understanding of how the agency is actually going to analyze the data, I think that piece is a little, it's a bit unclear. Again, 12/31 is the date for the employee count. So keep that in mind. At least that is what they shared. I hope that's in writing somewhere soon. And with that, I think we are at the top of the hour. So I hope I've done my best to answer as many questions. I know that some of this was very, very fast. And there's a lot of information that we certainly know that employers are seeking, and we are doing our best to identify that information. And I know the Department of Labor as well is going to be providing additional information. So we're on the lookout for that. Thank you so much for joining us. We really appreciate it. And we are available to answer any additional questions that you may have.